Good afternoon, everyone. My name is Jesselyn Brogan Walker. My pronouns are she, her, hers, and I'm the director of the American Bar Association's Legal Education Police Practices Consortium. To date, we have 58 member law schools across the United States who have committed to contributing to the national effort examining and addressing legal issues in policing and public safety, including conduct, oversight, and the evolving nature of police work. One goal of our work is to ensure we learn from one another to ensure we are all better positioned to address local issues related to public safety and reimagining policing, because we know that local attention can lead to national change. The consortium was founded following the murder of George Floyd in 2020. While his death and the resultant demand for reform at both the local and national levels provided the impetus for the consortium, the news cycle continues to remind us of the ongoing need for evidence-based, non-reactionary review and response to policing and public safety. We are reminded of this reality in reviewing the recent death of 21-year-old Takia Young in Ohio, or in responding to the 5 officer-involved shootings in less than 2 weeks in San Antonio, Texas. Just yesterday saw opening statements in the trial for 3 Tacoma, Washington police officers charged with the killing of Manuel Manny Ellis, a 33-year-old Black man in March of 2020. We hold these lives lost alongside the 81 line of duty deaths this year for law enforcement. Constitutional Policing, Striving for a More Perfect Union, the recent publication from the ABA State and Local Government Law section, could not have come at a better time, and I look forward to exploring this publication in more detail with 3 of the contributing authors today. But first, some housekeeping issues. I would ask that you use the Q&A function to submit your questions to the speakers. As well, the book is available to purchase online, and I will drop a link in the chat for you to purchase it. We do have a discount code for attendees and interested parties through the end of the month. You can get 20% off the purchase price by using the discount code CPSMP23, and I will put that into the chat shortly. Now we have some opening remarks from Jessica Ann Baker, who is the section chair of the State and Local Government Law section. Jessica is the executive director of the Land Use Law Center at Pace University. Professor Backer also administers the center's academic programs and guides student research. In addition, she is a lecturer and project supervisor at Yale School of the Environment, where she manages the school's land use clinic. She authors regular land use features in New York and national publications, and has edited numerous small books in the fields of land use and real estate law. Professor Backer was selected by the American Bar Association to receive the Jefferson B. Fordham Award, an award presented to a young practitioner who has shown great promise through her contributions to the field. She earned her law degree from Hobb Law in 2003, along with a certificate in environmental law. While unable to join us today virtually live, Professor Backer has provided us with filmed remarks. So you'll bear with me one moment while I pull those up to share with you.
On behalf of the ABA section of State and Local Government Law, thank you for joining the book launch event for our recent publication, Constitutional Policing, Striving for a More Perfect Union. I'm Jessica Basher. I'm the current chair of the section. The section of State and Local Government Law is the premier association for lawyers involved in urban, state, and local government law and policy. Lawyers representing countless government agencies from across the country turn to the section to access the latest expert information on issues that relate to their practice and share ideas and best practices with colleagues. This year, we are particularly focused on providing resources and programming for the members on not only constitutional policing, but also affordable housing, resiliency, voting laws, and gun laws, all important areas for our members. One goal for our section this year is to engage with law schools and law students on these important issues. This book provides such an opportunity and serves as a resource for law students on this cutting-edge issue. The publication provides the litigation roadmap in the area of policing and addresses topics such as qualified immunity, administrative complaints against police, and litigating civilian encounters. We are honored to have this publication as part of our section library of resources and thank the editor, Michael Hardy, and the authors for their efforts producing Constitutional Policing, Striving for a Perfect Union. Thank you.
Thank you to Professor Basher for her contributions to this conversation. And now to moderate our discussion today, I am honored to be joined by Dean Jelani Jefferson Exum. Dean Exum is a nationally recognized expert in sentencing law and procedure. Before joining academia, Dean Exum served as a law clerk for the Honorable James L. Dennis, United States Circuit Judge for the Fifth Circuit Court of Appeals, and the Honorable Eldon E. Fallon, United States District Judge for the Eastern District of Louisiana. Dean Jefferson Exum joined the Detroit Mercy Law faculty as the Philip J. McElroy Professor of Law in 2019 and as Dean for the School of Law in 2021. Dean Jefferson Exum is a member of the editorial board of the Federal Sentencing Reporter, and her work has been featured on prominent sentencing blogs such as Sentencing Law and Policy. She mainly writes in the area of sentencing law and policy, but her research interests also include comparative criminal law and procedure, policing, and the impact of race on criminal justice. Dean Exum is also an esteemed member of the consortium's advisory committee, and we're delighted to have her moderating our conversation today. Dean Exum, thank you so much for being with us and agreeing to participate in this conversation. I hand the floor to you.
Thank you so much, Jesselyn. It is really my pleasure to be here. Good afternoon, everyone. And thank you for that introduction. As stated, I'm Jelani Jefferson Exum, and I'm the Dean of the University of Detroit Mercy School of Law, which is a proud member of the ABA Legal Education Police Practices Consortium, on whose advisory committee I serve. Our membership is evidence of our school's mission of social justice and commitment to anti-racism. And my work on the advisory board has been important to my own professional identity and mission as well, of working toward justice in the criminal justice system, in policing, and in sentencing. So I was especially honored to be invited to be a part of this book project and to write the afterword for the book. It is, in my opinion, and I hope you will also agree in your own opinions, that it's a book of extreme importance at this particular moment, as we've witnessed the lack of justice for people like Breonna Taylor, witnessed the trials of the officers involved of the death of Elijah McClain, seen the federal and state charges against officers involved in the death of Tyree Nichols. We've tracked the conversations in Atlanta, Georgia on the development of Cop City, and followed the response to charges being dismissed against Philadelphia police officer who shot and killed Eddie Irizarry in August. So despite the many, many reasons to be alarmed by incidents of excessive police violence, some of the national coverage regarding policing reform has quieted since the summer of 2020, when the police murder of George Floyd launched so many of us into action. So, however, I'm heartened, I'd say, by this publication, which draws attention both to the progress as well as to the work that is still yet to be done as it relates to ensuring safety and security for all communities. This book actively contributes to that discussion by examining a variety of issues. And so if you take a look at the book's contents, it really covers many issues that are unique to the American policing system, including qualified immunity, accountability measures for officers and departments, civilian oversight, the role of consent decrees. The strengthening police community relations really does require an understanding and appreciation of all these issues as both standalone components and also as part of a larger whole. So I see this realized through this publication, as well as through the ongoing work of the ABA Legal Education Police Practices Consortium. The consortium, as it was indicated before, works with member law schools across the country to better understand and address policing and public safety issues at both the national and the local levels. This is accomplished through a law student fellowship program that connects students with organizations that are focused on police reform, and also through other administrative support and research. Additionally, the consortium recently supported the development of a police law, policy, and practices course, which provides law students with information regarding the history of policing, law surrounding the development of modern policing, and evidence-based policing practices. This class includes police officers from across the country to promote bilateral information sharing between law enforcement and law schools in the hopes of creating sustainable, meaningful partnerships between law schools and local police departments. So this webinar was scheduled as part of National Community Policing Week, a valuable reminder of the role that we can each play in this conversation. Regardless of whether you are a law school dean, faculty member, law student, practicing lawyer, or community member, we can all contribute to being a part of the change that we would like to see in policing and public safety in the United States. The title of the afterword that I wrote for this publication is "The Most Perfect Union Protects and Serves Us All." The success of police reform is a matter of life and death for certain people and certain populations in America. And I hope that through our conversation today and throughout your reading of this book, you will have a better understanding of the work that's required to achieve that most perfect union that really equitably provides safety for all communities in which the police are called to serve. So I trust that today's conversation will help us all to identify ways in which we can play an active role in striving for that form of justice. So in addition to moderating today's panel and having the pleasure of giving some opening remarks, I also have the honor of introducing our speakers who were both contributors to this text. They are extremely accomplished in their own rights and have many, many accolades. And so in the interest of time, I will share some brief highlights from their bios. So I'll start first with Mr. Michael Hardy. He has been a practicing attorney since 1988. He's admitted to the bar of the state of New York, each of the New York State Federal Districts, the Second Circuit Court of Appeals, and the Supreme Court of the United States. In 2008, he officially assumed the position of General Counsel to the National Action Network. He's one of the founding members of the National Action Network. He's been involved in movement politics and the fight for a more perfect union since 1981. Mr. Hardy has been in the forefront of key civil rights and police misconduct cases, including the matters of Eric Garner, Sean Bell, Amadou Diallo, and many, many others. He led the efforts for all of NAN's major civil disobedience actions to date, highlighted by his representation of the approximately 1,200 persons who were arrested during the 1999 Amadou Diallo protest at One Police Plaza in New York City. In April 2014, New York Governor Andrew Cuomo appointed Mr. Hardy as a member of the Commission on Youth, Public Safety, and Justice, which resulted in raising the age of criminal liability in New York from 16 to 18 years old. I could go on. I'll say one more piece about Mr. Hardy that I think is especially important here. Mr. Hardy participated in the U.S. Department of Justice's creation of the Clemency Project, where the Obama administration began an effort to release low-level drug offenders sentenced to life or near-life prison sentences under mandatory sentencing guidelines that would not be applicable today. We're very happy to have Mr. Hardy, and he was the editor of this book and gathered this group together, and so very much appreciate his efforts. Thank you. And I'd also like to introduce Mr. Wiley Stecklow. He's a noted civil rights attorney who was the 2021 Sarah T. Hughes Civil Rights Award honoree. Mr. Stecklow is a past president of the Southern District of New York chapter of the Federal Bar Association. He served as the FBA National Civil Rights Law Section Chair and has been an adjunct professor at Fordham Law School, his alma mater, since 2019. He's also a founding member of the National Action Network's Legal Rights Nights. For the past 20 years, he's been litigating policies and practices concerning constitutional rights in policing. He's litigated 1983 cases involving First Amendment rights in New York, Maryland, and Iowa, and tried constitutional cases to verdict in various state and federal courts, including a $1.3 million verdict in the Southern District of New York in 2019. In September 2011, his firm was retained by the Occupy Wall Street General Assembly. He organized pro bono representation for over 200 Occupy arrestees and litigated many dozens of civil rights suits relating to the policing of Occupy. The list goes on and on. He's involved in many major suits going on today regarding policing and policing fairness. And so also very pleased to have Mr. Steklow here and to have his contributions to this book. So thank you both.
Thank you so much, Dean. That was very nice.
Thank you. So I get to start off our conversation before we move into any audience questions. First, just by thinking about the importance of this book. Why this book? Why now? And so if I could turn to each of you to please just highlight some of the contributions of your respective chapters to just give us that insight into what the viewers can expect when they pick up this book and check it out. Starting with you, Mr. Hardy.
Well, thank you, Dean Jefferson Exum. It's a real pleasure to be here and to be joining everyone in this discussion. And of course, having worked on this project has been a very sincere honor and privilege. I personally was very honored when I was approached by the ABA to do this project. And at the time, you know, it was just coming together to talk about a particular book project. And, you know, just given my life and my work, you know, I have spent a good part of my life, what I always say, you know, striving for a more perfect union. And so, you know, I thought, I wanted to make sure I brought that in. And then, of course, I've always had my belief, which is supported in many ways, that in our effort, as we broadly understand the meaning of a more perfect union and what that means for this nation, what it means for this nation at this time in history, what it means for this nation in terms of the way in which our laws and government has evolved, you know, from the beginnings of this nation. It has always been, to me, and then you engaged us somewhat in your afterward, Dean. It has always been, you know, one of the great jewels of the Constitution. You know, there are always aspects of it that we can be critical of, but really, one of the great jewels was this document that was put together with a unique vision. That has allowed it, as many will often use, you know, the march of time has allowed that Constitution to really assume and shape and become the actual words that the document meant to be. And so when we came to this project, you know, I said there was no better combination in this current era than to talk about constitutional policing. And how the whole issue of policing and how it affects our communities, how it affects us individually, how it may have impacted various experiences that we may have experienced as we have gone through our own lives, how it has impacted family members. That when you think of how does America become everything that the enlightened individuals that dreamed of this Constitution thought that this nation could be, it really comes to a point where the relationship between community and policing is one of the key factors that has to continue to evolve in a way that will really make us to be a more perfect union. So it was an enormously motivating project, and obviously the whole areas of policing and what that means and how policing has evolved in this country, the respect that police maintain in society is clearly one of the most protected and respected areas of public service that one can enter into. And of course, what it means for certain communities, that simply as a result of the way laws and attitudes have been born and progressed in this country, have always sometimes been victims of that equation. And until we can really solve that equation, we really can't be a more perfect union. So that was really in a nutshell, if you will, a huge motivation for taking this project on. And again, the book and the chapters of the book cover so many aspects of that in very detailed and timely fashion.
Wonderful. Thank you so much. Mr. Steklow, what about your contribution to the book? Why was it important to you and why at this time?
Thank you. And I also want to thank you for that lovely introduction and thank the ABA for organizing this and putting this important book out there. First, I want to say something to the perhaps younger lawyers out there who are joining us today that gets back to why now. Your adversary is not necessarily your enemy. Your adversary is, a future colleague, a future friend, a future brother. And 20-something years ago, one of my adversaries was a man named Michael Hardy. And so I met Michael Hardy as an adversary on the opposite sides of a case, and we very quickly became good friends. And so it's been a great 20-year relationship that I hope goes for another 40 years. And the reason for me why right now is that when my brother Michael calls me and says, I'm publishing, I'm editing this book, and I'd like you to write a chapter on qualified immunity, the answer is right now, yes, of course, I will do that. And so that was my first reason. My first reason was because Michael asked. And anytime Michael asks, my answer is yes. The reason that I wrote about qualified immunity, which is chapter 1 in this important book, was because this is an issue that it's been around for a long time, right? It's been around for decades, but somehow in the general election of 2020, leading up to that in the primary election, I guess even before the general, this bizarre and unusually created, i.e. not from statute issue, this theory, qualified immunity, had become a topic in office, in cocktail parties, as people were getting water and chatting with each other. This idea of qualified immunity, this term was started being talked about, started being discussed. It started becoming a hot button topic. And I look back to, I think, and I wrote about this in the book, to Julian Castro, who at that time was one of the Democratic individuals running for office. And he talked about qualified immunity during a debate. And I think that really raised it, that put it on a national topic. It made it something people started talking about. And even after that, you started seeing NQI legislation. You have that locally, you have that in states and in cities, and in New York City. I can even discuss what happened to city council here a couple of years ago. But you also then had bipartisan legislation with Tim Scott, who I think is an individual now running for president as a Republican, who was working with Cory Booker, a Democrat, to create an end qualified immunity legislation. And I think that's one of the reasons why this is important now. For everything Michael said about why the entire topic of constitutional policing is important. I mean, I've spent my career dealing with the failures of policing to comply with the Constitution and trying to push, as I think Judge Bernice Donald, who I heard speak recently, had said, that you have these individuals and they are pulling and they're pushing that arc of justice. They're pushing it, towards morality. And they're really trying to make that work. And I think, the moral universe and pushing it towards justice can work when people are working together. And so qualified immunity is a real issue. It's a real problem. And I've spent my career trying to work on it. And so right now, it became a very hot button topic. We're very interested in what's going on with it. And I think that's why it was important to write about it now.
Hey, thank you for that. It's a perfect segue to my next question, thinking about a concept like qualified immunity and really all of the issues that were discussed in the constitutional policing book. We are confronted with issues that are sometimes political hot buttons. You walk out on the street and talk to people about policing. They probably have heard the term qualified immunity and many others, but may not know a ton about it. We have scholars writing about these various issues. We have legislators. We have reformists, all out talking about some of these issues. And so clearly this is something, if we want to really get to a place of equitable policing and public safety, where we need many different types of people at the table, a really collaborative effort. So if you're thinking about how people might actually come together to advance change, let's talk about the scholars, the legal scholars who are writing and researching in this area. What advice might you give, or what suggestions do you give on areas of focus to advance that cause of true constitutional policing or equitable policing reform? And Mr. Steckler, why don't I start with you this time?
Sure. So, I do think that there's really important scholarly issues arising right now. And again, I'm going to focus on qualified immunity. That's what my chapter is about. And so that's what I'm going to discuss. Last year, Professor Alex Reinert, who is, an incredibly intelligent and well-respected scholar who teaches at Cardozo School of Law here in New York, he published an amazing article, almost a treatise at this point, that basically he did a deep dive into the background of 1983 and into the original legislation itself, and he found the actual document, and he found that the current qualified immunity precedent derives from the premise that the Supreme Court has said there is no evidence that Congress intended to abrogate the traditional common law immunities in Section 1983 cases, and that's why we will have prosecutorial immunity. That's why we'll have qualified immunity. However, that is wrong, and that's what Professor Reinert found. He found that there was specific language within the original statute that identifies an abrogation of those immunities, that it does not apply to this statute. And so it's my hope that based on that, we'll have more scholars writing about it, and not just scholars, that we'll have media paying attention to it. I've reached out to the New York Times to discuss it with them, to tell them I think there's actually a really important issue that is topical. It's about qualified immunity. And as we all know, especially if you read the chapter, qualified immunity was not created by statute. It was created by the Supreme Court. They decided they were going to take a common law immunity that existed in Mississippi and expand upon that to give the idea of good faith immunity. If in fact the police officer in good faith did whatever it is that he's being sued for, then he won't be held responsible for it. And they've then taken that over the last 50 years and stretched it and stretched it and stretched it to now you will only hold the police liable for the most incompetent of acts. And that's just not, that's clearly not the intent of the Congress, because we now have the actual language, and it's not going to really allow for 1983 to exist and protect people like it was intended to. So my hope is that we'll have scholars continue to do that. I know that there's an amazing lawyer down in Louisiana named William Most. He's drafted a brief that he shared with all the civil rights lawyers he knows, saying if you get a qualified immunity, here's the arguments to make. Here's a sample brief to use. So between scholars like that, amazing lawyers like that, and hopefully some journalists, we'll get some traction here. So the Supreme Court will have to face this decision, because they were recently had a cert petition. A Fifth Circuit judge relied upon that. And then there was a cert petition to bring it to their attention. Hey, Supreme Court, you've got this issue that maybe changes a big topic that people are looking at, and they denied cert. And so they're sort of trying to be blind about it and pretend it doesn't exist. So hopefully there's enough attention out there. It'll put pressure, and the Supreme Court will have to decide it. There's now a Seventh Circuit case that's also coming up for cert review. And if that one, maybe there's enough pressure, maybe they'll have to accept that one. And then maybe qualified immunity will be disbanded by its own statute, by its own statutory language.
Wouldn't that be something, right? This has been a topic that definitely has felt like it's just been set for quite some time. And so it's encouraging to hear that there may be an opportunity for some movement in this area. Okay, well, Mr. Hardy, so we have now kind of one avenue where it's really ripe for scholarship, for research, for collaboration around just really making noise around something that we thought was set that may actually make some real change. What's another topic or set of topics that you think is really ripe for research, for scholarly attention in making some real change in the area of policing?
Well, I really have to turn to the book. I mean, I think the way that the book was put together And if you just go down the table of contents, the book starts out with the discussion of qualified immunity. But then, of course, it moves into the whole structure of policing. So we have a chapter on, dealing with administrative complaints against police. How not only individual police departments handle the internal discipline of their officers, but the ways in which both government, in terms of some of the local and state laws that are developed around how police departments have to be governed, and of course, the way localities deal with it within individual police departments is crucial. I mean, police, again, over time, police have come to learn that when they become police officers, it is not a free rein. You are endowing someone with a tremendous amount of authority and power when you give them a badge and a gun and the ability to arrest people. That is an enormous amount of power, and look, anyone that has that amount of power, it is easily abused. And so over the course of time, how police departments have come and grown to learn to discipline their officers. That's very important, and of course, that's one of the chapters in the book. Then, of course, police are public officers. And so we have the chapter on accountability of public employees because they are public employees. We, the taxpayers, are the ones that fund not only the government, but fund the police departments that are to serve and protect us. And so they have to be accountable. And one of the chapters in the book addressed that in detail. And then, of course, we had the privilege of having the New York Civil Liberties literally collectively submit a chapter. And in their chapter, they talk about a law that existed in New York State, which was called the 50A law, which basically barred access to police disciplinary records, which was really important, and it was a long fight to get that law changed and vacated, frankly. And this happens all across the country. So, addressing police as public employees, keeping them, having them be submitted to the rules and regulations that all public employees, have to submit to is very important. And then, of course, you have the different aspects of that. It was a huge fight to really create a civilian review of police departments. And that was a fight usually on local levels because, again, as an institution, policing is very powerful. Not only are they powerful by the nature of the job that they perform and the power that goes with that job, they're powerful because they also have collective bargaining and they have unions that protect them in every way, shape, and form. And they're respected. I mean, people look up to police. I mean, you have children are born, and any kid in any home at some point is either playing cops and robbers, or they may run around and decide, hey, I want to be a firefighter. And so you see kids playing cops and robbers and being firefighters. I mean, these are important parts of our community. And so that becomes important, but also then what happens when that goes wrong? And that's where civilian oversight of policing is important. And it's been a big fight, creating civilian complaint review boards and giving them the powers that police have to be aware of and respect what may or may not happen as a result of civilian complaint reviews is important. And we have a chapter, that addresses that. And then again, you have the whole issue of that chapter 7 in the book, which William Hemmering discusses, is the whole, anyone that has been through a police trial sometimes is shocked by some of the testimony and the way in which the qualification of police experts are handled. And frankly, some of the testimony of policing that is allowed. I'm sure a lot of people on this call and watching have heard the term test-a-lying. I mean, communities and courts have struggled with the fact that police officers with a straight face will get on the stand under oath and lie. And you saw that evolve a lot, particularly during the war on drugs in this country. And it's only now that the total institutions that control policing, and of course, the outside citizens through civilian complaints and other forms, have begun to put some restraints on that. So I would say that those are areas that lawyers at all levels, that professors at all levels, that scholars at all levels have to continue to focus on, because those are important issues that have to continue to be developed. And then you come to the other aspects, and which is the chapter that I had the privilege of writing, which really studied how, and is commendable, the way in which the Civil Rights Bureau of the United States Department of Justice has really stepped forward to exercise their oversight of local policing. And when you bring the power of the federal government to that oversight, it has tremendous results. And you look at, in the last few years, even as a result of George Floyd and Trayvon Martin and even now Tyrese Nichols and some of the other cases that are happening, the Justice Department and the Civil Rights Bureau of the Justice Department has been very responsive. And they have really begun to use the tools that we as citizens, because we elect the legislators, that get into office and make these laws. And there's a tremendous body of law with regard to oversight of policing at the federal level that in the past has not been used to really enhance a more perfect union. In other words, to not just respect and protect the police, and respect some of the laws that are there to protect how police officers are governed, but also to protect the citizenry when they are abused or become the subject of unconstitutional policing. And we explore that in detail in our chapter on pattern and practice investigations.
Thank you for that. There's certainly a lot to cover, a lot of work to do, and you both gave excellent explanations of some of the ways that we can come together at different levels of the law to start to address some of these issues. We do have at least one question that's in the chat that I wanted to, I'm going out of order a little bit, but just because it was on point to what was just being discussed. Mr. Hardy, you were talking about oversight, civilian oversight of officers in different ways. And but you also mentioned that there is enormous respect for police as well. And so this question sort of strikes at that balance. Mr. Stecklow already started to answer it, but I'm going to read the question for you to see if you have an additional response. The question says, if qualified immunity has been expanded over and over to the point that police officers are protected except for the most egregious conduct, if qualified immunity became limited or set aside, Where is the middle ground to protect police agencies and officers from excessive unwarranted lawsuits? So, so this attendee is really asking about that balance between protecting the public, but also being protective of officers. Mr. Stecklow gave an answer, and I'll give you the last line of that answer. Says the best way to protect police agencies is to have proper training. Mr. Hardy, do you have views on thinking about how there might be a concern out there that some of the reform measures that are being pushed for would be damaging to police officers?
Well, yeah, I do have concerns, and again, police officers, they do have to be protected, but they can't be shielded in a total encompassing way, because once you shield, I mean, look, even presidents of the United States are subject to impeachment, and so police have to. Part of that is culture, and policing is there is a culture of its own in policing, but they also really are part of the larger community, and so therefore you have to have access to them. They can't be completely shielded, and I think most of the progress, again, there are state and local laws and communities, for instance, even on local levels. You cannot just sue police officers. You have to be able to establish particular violations, and you have to also establish that localities have ignored the laws that are in place in order to then proceed against a municipality or a state for the way in which policing has occurred. So I think it's a mistake sometimes to think that there's not sufficient protection for policing. Every day legislators wake up, trust me, among the things that they think about most when they go to work is to make sure that they are protecting the public servants within their jurisdiction. And so I don't think it'll ever be the case where there's such an imbalance that police just become victims of frivolous lawsuits. I don't believe the law is structured that way. I don't believe government is structured that way. And frankly, I don't think individual citizens are, nobody wants to necessarily go to court, so I don't even think individual citizens would love nothing more than to have a good working relationship with police in a properly regulated society. And that's what we strive for. And again, it's not perfect, but all of the little tweaks we do help that to come along. And more importantly, it is important that every community feels that they're part of that equation and are not left out.
I'd like to just add a little something to that because there's a qualified immunity topic. And then there is a concern that if qualified immunity is simply abolished, then the officers themselves would be held liable, and the counties and cities could say, we're not indemnifying. And therefore, you're going to have individuals with harm who are going to have pieces of paper of judgment without the ability to enforce them because the officers aren't going to have the funds to support it. So you are going to have to do something. The cities will have to do something if there is an abolishment of qualified immunity about having a requirement of indemnifying. If you're going to put people on the street and you're going to claim that they're properly trained to be given the trust by our community of being law enforcement, then you're going to have to indemnify them for their conduct, right? And I think that the last thing that I've heard is that this might put small cities and small cities with police forces out of business. It'll force them into bankruptcy, and I think that the answer to that might be not every small city should have their own police department. If you cannot afford to do the proper training and have police properly trained on the street, maybe you need to rely on the county or the state for their law enforcement help and not have your own police department because you're your own small town.
Thank you for that. Yeah, and I think you really open up this idea of reimagining what policing looks like, where, if we're going to have some real reform and really address these issues, then we have to confront the thought that maybe policing needs to look differently in so many different ways from what we're seeing, including you know, who funds police and what communities are involved in decision making and all of that. Okay, so you both mentioned training. And Mr. Hardy, you just said we've been making some little tweaks that that lead us to progress. Mr. Stecklow, you said even in response to this qualified immunity question, that the real proper response is training. So let's talk about that. Are there any initiatives? So training being one of them, policies either proposed or passed, community-led efforts, things that you can identify as really happening out there in the real world that give you hope that policing is evolving, that there is some movement in the right direction. So let's start with that. But of course, if you're not seeing that and you'd like to add in some actions that you think should still be taken, please identify those as well.
Sure.
Mr. Stecklow, would you like to start?
Sure. Thank you. So, you know, the idea of community policing is the right idea, right? The words sound right, the theory sounds right. But between theory and reality is a huge chasm of space. And I really don't see a lot of community policing success, at least not in New York City, because I just don't see the community trusting the police. You can't have decades of mistrust cured overnight, right? It's going to take time. But there was an initiative that I do want to discuss because I do think it's interesting, I think it's important, and maybe it will lead as an example for other locations and other jurisprudence. So back in summer of 2020, right, we all remember what happened to George Floyd. We all remember that he was killed and it was recorded, and we all had to watch his death in real, in slow action and just be absolutely horrified by it. And people took to the streets, and people had been locked up in their homes, for months at that point. So people were ready to hit the streets, and protests went all over this country, including in New York City. And, one thing that we could probably all agree on, police don't like when people protest police. Right. And it's an unfortunate situation. They're the ones who are now going to be policing you when you're protesting their policing. But that's what happened that summer of 2020. And in New York, there was, in my opinion, an over response by the police to the protest. And there were multiple lawsuits filed that were consolidated. 8 or 9 of them were consolidated. The rest 50 or 100 were stayed. But I was counsel on 2 of them that were consolidated. And they're consolidated under the name of In Re New York City Policing during summer 2020 demonstrations. And the Attorney General filed one of them, Tish James. New York Civil Liberties Union filed one, Legal Aid Society, a couple other law firms, Cohen and Green and I, and Beldock, Levine and Hoffman filed one. And we were all consolidated, and we worked for 3 years litigating really hard. And then for a year in mediations and settlement conversations, we had the police unions involved. And so we came up with a system that is part of a settlement document that has now been approved, and pending one motion, we'll have it and become reality. And it has tiers. It has 4 different tiers about at what level at protest can the police show up, at what level, what has to happen for them to show up in force, what has to happen for them to take enforcement action, and things that we think are extremely important. As I've been litigating these cases for more than 20 years, I've always seen the idea of de-escalation being an idea, but on the street, it's escalation. When the police show up, things get more tense, more anxiety, more stress. And so the hope is that through these tiers, we can de-escalate. We can force de-escalation by not allowing them to escalate. On top of that, we've got a training component about having to retrain them in certain ways. And then we have sort of an after review where we've got the New York State Department of Investigation in charge of reviewing a certain number of First Amendment activities each year for the next few years. And if they're in compliance and everything's going according to the agreement, then that ends and the agreement stays in force. If they're not in compliance, then their review will continue. And so I do think this is a very unique situation. There are some incredibly smart lawyers who are helping this. One of them was Jessica Clark, who's now sitting in the Southern District. So Honorable Judge Jessica Clark, shout out to you. We had Corey Stoughton and Molly Bicklin being 2 other amazing lawyers who worked on this. So we had really phenomenal lawyers working on this together and came up with this really incredible plan. And I do think that's the type of initiative that maybe can be played out in other big cities that are having issues between law enforcement and the citizenry.
Wonderful. Thank you. Thank you for that explanation. Mr. Hardy, what are you seeing out there that's giving you hope or initiatives that you think could be expanded examples?
Well, I think one, just picking up a little bit on what Attorney Steckwell just said, is I do think community policing has to continue to be a national goal. Because again, aspirations are important. And so if you're striving to be community, at every level, the various efforts, whether you're a legislator, whether you're a supervisor in a police station, or whether you're a community leader, you're going to be looking at ways in which you can both serve and protect your community. And so that fosters cooperation. And again, it may sound a long way away, but you still see it coming closer and closer. And again, sometimes a lawsuit or a class action has to be one of those things that really hit people on the head and say, oh, okay, the light bulb has gone on now, and we have to begin making these changes. But I think the whole model and theory behind community policing is important. So I mean, that's number one. Number two, again, on a litigation level, and again, I would focus people to both chapters 7 and 8 of the book. In chapter 7, William Hemmering really takes a look at how the issue of qualifying experts who testify with regard to police practices, and how that has been historically abused, and in some respects abused because what it takes to become a qualified police expert in a trial is really severely under oversight. There's a lot of reform that's required there, and William really brings that out in his chapters, and there are real issues that, if you read and study that chapter, should give attorneys who are practicing and those who are legislating great ideas as to how to address this important issue of qualifying police witnesses. And then again, the second issue, of course, which is always a critical issue, is the use of force. And Mr. Hemmering in his chapter really dives into the abuses sometimes in how the courts deal with both the testimony of police officers and the rules of evidence that the courts use in terms of corralling the whole issue of use of force. And so there's a lot of work I think that can be done there. Again, both on a legislative level and both on a litigation level, and I'm sure we'll see a lot of that happening. And then, of course, in chapter 8, the team from the Civil Liberties Union, they really, took on the issue of basically what is called broken windows policing. And that was something that people can go back and remember, at least here in New York, when Giuliani came into office. He made this promise that he was going to shut down the squeegee guys, who were homeless guys who used to stand at the highway entrances, that when cars had to stop, they would come and try to wash the windows and ask for a little handout. And there was a theory that evolved called broken windows policing that said, well, if you allow squeegee men or women to do what they do, that is going to lead to tremendous levels of more complicated, sophisticated criminal activity. And I think that was a false theory, and I think that was a real attack on community being involved with their policing agencies. And we are now recovering from that. And that was a 20-year building up of broken window policing. And we're now in the process of beginning to break that down and refocusing on the issues of community policing which I think are important. And then, of course, I think also on the local level, there are some old structures that are still worth investing in. I think police athletic leagues are very, very important, and I think are overlooked and underutilized. And then you have other communities that do various kinds of programs. I've experienced programs that were called Cops and Kids, that literally brought working police officers together with underprivileged, well, I shouldn't say underprivileged, underserved communities, so that they could literally engage in dialogue. You could even call it a form of therapy that really allowed each to explore their fears of each other. And I think those kinds of human relations in the context of community becomes very, very important to the whole respect that police may have for the people that they serve, and allowing the community to once again, respect the officers that protect them. I can remember a time when I was a kid in my own community that policing was a little different. I mean, when I was growing up, and now you're talking in the, early 60s, there were times back then, even in Brooklyn, New York, where police would take you by the hand, not arrest you, not beat you, but take you to your parents and say, I saw him doing X, Y, and Z, and I'm bringing him to you to let you know. And your parents would take you upstairs and give you a licking that, wouldn't stop ticking. But, it works. And while those may be ideal aspirations, I think that's who we are within the law and within this country. We're always seeking to aspire to be better than we are now. And I think that's one of the key factors in everyone buying into what community policing and the community policing models are all about.
Thank you for that. It's good to hear that you have hope for that model. And I know that it has been something that's discussed so often and unclear, I think, on where it's being done well and what are the roads to really getting there. But you make some great points that there are some perhaps even instances of how policing used to feel in certain neighborhoods that we could draw from. Thank you for that. Well, we're at a point where we can turn to some of our questions from our listeners today. And we have one that comes from one of our consortium fellows who asks, the question says, I'm curious whether the book directly addresses police use of deceptive practices or deception, especially during interrogations, investigations. So not just talking about this term test-a-lying, but in previous portions of the process. He says, I know there was mention of detailing pattern and practice investigations. So Mr. Hardy, starting with you, can you speak a bit more about what expecting readers may find in the book regarding these specific policies or practices that really focus on deception or deceptive practices by police, but in the investigative phase?
Yeah, well, I think the pattern or practice portion of the book is important because the federal government is uniquely situated, particularly as it relates to its oversight of local policing on the state and local level, and they have gotten very they have really tuned in to when that need arises. Now, granted, they are not going to get involved in smaller issues that happen, particularly with deceptive policing on smaller levels. It's usually when there really are pattern or practices that will require them to step in. So it does then become more of a local issue. And again, I think Mr. Hemmering addresses some of that in his chapter because, again, it really does deal with the way in which police internally are dealing with these issues, because a lot of it has to do with the leadership of the departments. And so, all of the aspects with regard to governing police departments internally become important to that, because those that supervise those departments, the captains of police stations, the commanders of a precinct, ultimately they're going to be the ones that are responsible when a deceptive practice leads to something much more serious. And so, as with anything, the more local commanders and sergeants at that level are trained to address those issues, and the police disciplinary structure is more in tune to dealing with that, again, because some of those deceptive practices are going to be mostly exposed when there are courageous police officers that can bring that to the attention of the supervising officers. And again, I think when those police officers who can courageously not feel as though they are turning on their fellow officers, but are protecting the institution, will we really begin to make some progress there. And let me say this, I think that particular issue, yes, I think it could have been more thoroughly addressed in some of the chapters. But again, books are limited in their own respect too.
Right, there's so much to cover. You can't cover it all.
Right.
But I will say this book definitely covers a lot of it. It really, really is a great read with such a breadth of information. Mr. Stecklow, did you want to add anything to that, thinking about addressing deceptive practices by the police before they're in court?
Right, and I do think that it's a difficulty. People, I mean, at least I know I need to counsel my clients and let them know that the police are allowed to lie to you when they question you, right? You may not be allowed to lie to them, but they're absolutely, your co-defendant just said you did it. So if you want to get out in front of this, you got to make sure you tell us the truth right now. He said that, I didn't do anything, it was all him. That's the sort of thing they're allowed to do, and you just need to know that. And I don't, as far as seeing like Main Justice taking on pattern and practice investigations, I've tried to deal with them and tried to get them to look at different things for clients. One was in South Carolina, a specific place there, where there was an African-American artist who was touring with a Confederacy themed, an anti-Confederacy themed show. And the local police stormed his residency where he was staying, which is also where the art was being shown, with police, with guns drawn. And so we tried to get DOJ in, they spoke with us, and they said that the only way, they got a lot of calls, the only way they can actually start an investigation is that they can see a huge pattern, a history. So not just something that's happening now, but we need to see a history of that. So if you can show us a history of that, then we can look at it. We get a lot of calls from a lot of different places, and they were nice enough to take the meeting, but it didn't go anywhere from there. So it is difficult. It's very difficult because it's just a limited number of, I guess, people in Main Justice who do this type of work.
Well, that answer is a nice segue to this next question, where your answer may be similar, but let's see. The question starts by thanking us for the webinar and saying that they will purchase the book after the presentation. So I thought that was important to say. So thank you out there for those of you who are purchasing the book. But she goes on to say, I'm a forensic psychologist in Minneapolis, and one of my areas of expertise is to review and critique investigative processes, including forensic interviews conducted by law enforcement with children and adults, alleged victims, witnesses, and the accused. And then goes on to say, there appears to be a lack of accountability in policing in this area, with many interviews not following international and national guidelines. I wonder if you have any comments on this. So I gather this is another area that's really hard to address, especially from a litigation standpoint. But what are your thoughts on whether what is the lay of the land here? Is there any opening for real reform in this area that either of you are seeing? I'll take whoever, as you mull it over, whoever would like to start, and just jump on in.
It's not an area that I'm very familiar with, so I don't really have a lot to add to it.
Okay. Mr. Hardy?
Yeah. Well, again, I would say that obviously it's a very serious concern. But again, I think that's where the internal workings of police departments become important. And because those are the types of things that have to be managed internally. Because first of all, they don't get exposed ultimately until something either leaks out or inadvertently leaks out. And then broader investigatory agencies can become aware of it. But generally, these are just things that happen internally. And so, and again, I think there's movement there, but that's where some of the civilian review boards, the police review boards, the disciplinary review boards, and of course the role that the internal affairs bureaus can play within policing, and that's a whole chapter of a book on policing that would really be worth looking at, because internal affairs can have a huge impact on correcting all kinds of improper or sleight of hand practices that may happen within the internal workings of a department or an investigation.
Great. Well, you're anticipating the next questions and talking about civilian review boards. Because another attendee has asked, for civilian review to become effective and eventually accepted, what qualifications and training should the civilians have before being allowed to participate in the process? So, Mr. Hardy, what are your thoughts there on actually having effective civilian review boards that that will be respected and given a real role in the process?
Well, I think that's on two levels. I mean, one, a civilian review board does have to reflect the civilians in that particular jurisdiction. And so, I think it's a level of both having a pure community level, and then I think a lot of civilian review boards, including when they select, let's say, the executive director of that board, or the leading investigator of that board, they may be those that might have more training in that area. For instance, one of the questioners just now, whose background was in studying the interview tactics and of police departments, people like that that you look for to qualify them to be part of that review board. But then there does need to be common sense community people on those review boards to keep it real, if you will, and to keep that connection with the community.
Yeah, Mr. Steklow, any additional insights?
Yeah, I mean, I work with the New York Civilian Complaint Review Board all the time. I think I currently have 7 investigations ongoing with them. And I think that's somewhat unique. I don't think that all the civil rights lawyers buy into the CCRB. I do. I buy in wholeheartedly. A lot of respect for John Darsh and the investigators over there. I think that, as Michael said, that the people who are going to serve on the CCRB or any sort of community policing board need to reflect the citizenry of that community. And do they have to have any requirements of education or background? I don't think they should. I think they should be similar to the community, and that they should emulate that. And that should be, I think, what should be the background of those individuals. If there's a question, for me, the question I wasn't sure, if it's a question of what training or background somebody should have in order to bring a complaint, the answer there is obviously none. Any citizen should be able to bring a complaint. One of the great things about the CCRB is you can file a complaint if you see police misconduct on someone else. You don't have to be the victim of the police misconduct in order to file it. So I think that's extremely important. And I just want to say one other thing about training, going back a little bit, because I don't think I made this clear. A lot of the problems with training that I see are not problems that recruit or academy training. Like in New York, you have somebody who wants to be an officer, they're called a recruit. They go into the academy, they're called a cadet. They spend 6 months at the academy, taking a lot of training, some classes, some on their feet type of training, and then they get on the job. They get to become a police officer. In the next 20 years, if they rise through the ranks, they become a high-ranking supervising officer, but yet they have not had refresher training. They have not gone back and been given an update. The law sometimes changes. The Constitution has been interpreted in a certain way to apply differently for street stops or sidewalk stops or other issues. And the senior officers not getting refresher training. So the biggest problem I see with training is not necessarily at the academy level, but it's post-academy refresher training. I just wanted to make that clear.
Thank you.
Yeah, and let me jump in again real quick, because Wiley just made me realize that, again, I think chapter 2 of the book on constitutional policing, the key thing in that chapter that I think is very relevant to this discussion is the whole notion that policing, that police officers should have to go under periodic psychological review. I think mental health of police officers is enormously important, and there's not enough focus or requirements throughout police departments that require a more thorough monitoring of the well-being, the psychological well-being of police officers, including the environments that they're going home to. And I think that is very important, and we do touch on that particular issue in chapter 2 of the book.
Thank you for that addition. It's very helpful, very important. I just have one other question before we move to concluding remarks. So everyone who's tuned in today may not be a practicing attorney in this area, may not be a law professor, a law student. So maybe other interested people in the community, or lawyers who practice in a different area, or someone who feels that this is not their area of expertise. If you're in a place where there's not an opportunity to be on a civilian review board, or to be someone who is in the middle of criminal justice reform as part of your job, what would you like to leave with people about how they can be involved in advocating for some of the changes that have been identified in the book as necessary, that you've talked about today? How can people be involved if this is not their day-to-day job and taking these cases on or writing in this area? And Mr. Steklow, would you like to begin with this one?
Sure. I mean, I often describe myself as an activist attorney. And I think that is because I will always try to help friends, colleagues, and others who go out onto the street, put their bodies on the line to try to effectuate change in our society, good change, positive change. You know, people who get into what the late, great John Lewis would say is into good trouble. And so people who get into good trouble will have me by their side, and I will be there to help them. So tomorrow, Thursday, October 5th, is a return date for 150 people who were arrested September 18th protesting and trying to bring attention to the climate disaster we're all living through right now. Right, in New York, we got to see a lot of that climate disaster last Friday when there was flooding that we hadn't seen in many years. And so these people have summons, 150 of them summons that are going to be returnable to court tomorrow. I'm taking my law students with me, and we are going to represent at least half of them tomorrow in court for free, because that's what they deserve. So if you don't know how to get involved, you know, and there's a protest that's going on, hit the streets, give them more people, give them volume. I'm not telling you to get arrested, right? That's a choice you can make, whether you want to participate in civil disobedience, which is perhaps a step past First Amendment activity. But how to get involved is doing that. Go support that, or find a local politician who has the same beliefs as you and go support that individual, go help them. It's not necessarily easy to know exactly what to do. You know, it's not, you know, if you go onto Facebook or social media and share things, is that really moving the needle at all? You know, I think it's making a sign, going down to the street and taking your opinion to the public square. I think that's what our founding fathers believed in. That's why they created the First Amendment, to protect people's right to publicly assemble and to petition their government for a redress of grievances. And I say exercise that right. And if you get into trouble doing so, give me a call. I'll be there for you.
Wonderful. Thank you. Mr. Hardy.
Yeah, I will tag on to that, you know, by saying that, look, we all live in communities. I mean, it doesn't have to be something special. It could be, you doing something in your church. It could be you doing something in your block association. It could be you, your involvement in the PTA at a local school. There are just so many ways that you can help influence what is happening in your community, including in these subtle ways. How your community is being policed, and how other officials in your community, are being responsive or non-responsive to the needs of the community. So it happens from the home, you know, to all of the different things you may be involved in. Obviously here in New York, and I'll give a quick shout out. We do at National Action Network. Not only do we maintain a crisis center, so that no matter what it is, it could be anything. It could be that you can't find somebody to help you with a bad prick in your toe and you feel like you're in crisis. We give people a place to go where they can express themselves and seek help. We hold a legal night once a month, where we have a group of attorneys who volunteer. These are people who either have been totally thrown out of the courts or have no ability to bring an issue into court. But we give them an opportunity to speak to trained legal minds to help them resolve personal issues that they may be dealing with. So, participate in programs like that in your local communities. Maybe there's a program like that in your own community. Go out there one night and find ways in which you might be able to contribute whatever your expertise may be, in a manner that will not only help those that are in need of that help, whether they are police or civilians who are subject of policing, but will help you in your own way, with your own families and within your own communities. I mean, the avenues are there on so many levels to make a contribution.
Thank you both for that. So we have our call to action and some steps to take for people to be involved. And as we wrap up our program, I wanted to give both of our wonderful speakers who have, again, just made such a valuable contribution to this project, but also to this discourse on policing and where we can go to have a more equitable, safe system for all communities. But I'd like to give you the opportunity to give some closing thoughts. What do you want people to take away from this project? What would you like to leave this group with? What are your big dreams here? However, whatever you'd like to leave with us. Oh, this is the time when everybody's phone goes off for the national, I don't know what it is, alert. So everybody's phone's going off.
Yeah, testing.
Yes, alert testing. But what do you want to leave with everyone? Just give you all a few moments to think about that and impart these final words to this group. Mr. Steklow, would you like to start?
Sure. First, I want to thank the ABA, and I want to thank Dean Exum and Jessalyn Walker for their work in organizing today, and for my brother Michael Hardy for inviting me to be an author here and to join in putting this book together. It's been a great experience today, as well as the entire working on this book with Michael Hardy. What I'd like to leave the folks with is an idea that, we live in a society and we give law enforcement the right to police us. That's our right we're giving to them. And with that comes, a modicum of trust and confidence that to date has often been abused. And, if you see how policing is done outside of this country, it might actually surprise you. It might surprise you to know that they don't all carry weapons. They don't all carry guns. They don't all, as Michael said, think to arrest first. Perhaps their first thought is to take that person home, get them somewhere safe. I do think that we have a very long way to go to undo the last few decades of mistrust between law enforcement and the community. I do think that there is a need for police in our country, and that I think that we need to continue to work towards this more perfect union that Michael Hardy keeps discussing. So with that, I'll thank you again for having me here. And so it's been my honor and privilege to join all of you.
Thank you so very much. Mr. Hardy, concluding remarks.
Well, I will start by Dean, the chapter of your afterword, which is the most perfect union protects and serves us all. And I think your words in the afterword are very significant. Of course, I want to thank the Bar Association. I want to thank the state and city section. I want to thank Jesselyn and you, Dean, for leading us in this discussion. I want to urge everybody, this is an important area of the law. And I think the more people that are in the profession that practice in this area can continue to do things to keep advancing us because there's still so much area that needs to be covered. And there's so many different ways that we can work on so many different levels, whether it's in the actual legislatures, whether it's in the community, whether it's even volunteering at a local police station. There's just so many steps that we need to take, but we're on the right road. And I think as a nation, we're on the right road, and we have to keep pushing that because, even as a nation, we don't live in a vacuum. And we face dangers on every level all around us. Everything, as Wiley just said, from climate to individual situations that may happen around the world. And until we all become more sensitive to this, it's going to continue to be a problem. And it's only when people with the expertise that they may have, if you're a lawyer, be a lawyer that is dedicated to doing the right thing. If you're a police officer, be a police officer that's dedicated to doing the right thing. If you're a teacher, if you're a sanitation worker, again, it really doesn't level. It all comes together. And I'm a dreamer, and you probably hear that in so much of what I say, because I really do. More than anything else, I believe in life. And we have a short time in our lives on this earth. And in so many ways, not everybody makes the grand impact, but on every level, we continue to make an impact that can help our families, help our communities, help our nation be a more perfect union. And so I urge people to do that and do it to the best of your ability.
Thank you so much. Thank you to both of you for the work you've done, the work you continue to do, and for just continuing to show up for justice, really, and to inspire others to do the same. This has been a wonderful program. It's definitely been my honor to be a part of it and to be involved in this book. So I also would like to thank Jesselyn, the ABA, and to Mr. Hardy and Mr. Stecklow for participating in this and for inviting me to do so as well. I know that Jesselyn has some closing remarks that she'd like to share with the group, so I'll turn things over to her and let her take it over from here. But thank you all.
Thank you all so much. I know there's been a surplus of gratitude expressed in the last few minutes, but allow me to add my voice to the conversation. Thank you, Michael, for your charge in putting together this book. Wiley, thank you for your contributions to this conversation as well as the publication. And Dean Exum, thank you for your leadership in facilitating our call today, as well as in the great work that you did in authoring the afterword of this publication. I'm really heartened by our conversation today, both in the translational component that I've heard a lot of. The book is very approachable, but I think our conversation today has really helped to realize more of the goals of what we can accomplish when we're working together, particularly the different ways in which we can utilize our legal scholarship as well as our passion and energy. So I want to build off of Michael, your words just now, and express gratitude to you all in the audience for dreaming with us as we try to realize this vision of a more safe, equitable future. I think it is only through our collaborative efforts and trying to meet each other where we are that we're going to be able to see the progress that we're all striving towards. So thank you for being part of this conversation. Thank you to those who contributed to this book. Thank you to those who will read and apply the lessons from this book. We are going to together be a part of the change that we all hope to see. For additional information about the ABA Legal Education Police Practices Consortium, I encourage you to check out our website, the link to which I've put in our chat. For questions, comments, concerns about the event today, please feel free to email me at leppc@americanbar.org. Thank you all for being with us today. We wish you a healthy and safe afternoon and rest of your week. Thank you. Be well.